The Supreme Court Constitution Bench comprising Chief Justice of India UU Lalit, Justices Dinesh Maheshwari, S. Ravindra Bhat, Bela M. Trivedi and J.B. Pardiwala on Thursday continued hearing a batch of petitions challenging the constitutional validity of the 10% quota in education institutions and government jobs for economically weaker sections of citizens, popularly known as the EWS reservation. For those of you who are unaware of this issue, back in January 12, 2019, the Union government had brought about a constitutional amendment to Articles 15 and 16 of the Constitution, which deal with the right to equality and reservations. Prior to this, there were only provisions for seats and jobs to be reserved for scheduled castes and scheduled tribes and socially and educationally backward classes. Thus, pursuant to this amendment, the government introduced a 10% reservation for general category citizens who are economically weaker. The central government has defined economically weaker sections as those with an annual family income of less than Rs 8 lakhs. Subsequently, several petitions were filed before the Supreme Court challenging this constitutional amendment on the ground that it violates the basic structure of the Constitution of India. We have made a detailed video on the arguments advanced during the prior two hearings as well as the courtroom exchanges, the link to which has been given in the description box below. Please do check it out. Yesterday's pleadings were advanced by a host of counsels on behalf of the petitioners. The hearing in the case is slated to take place next on Tuesday before the Constitution Bench. Let us now see in detail what were the arguments that were made in the Supreme Court yesterday. Advocate Shadan Farasat commenced his submissions yesterday by stating that originally reservations were granted solely on an anti-discrimination basis and not on an anti-deprivation basis. He stated that this was a basic structure which was being violated by the new amendment, which granted reservations on the basis of deprivation. He took his arguments one step further and stated that even if it were assumed that reservations could be an anti-deprivation measure, exclusion of backward classes when they were in fact poorer than the forward class poor was a direct violation of the Equality Code as enumerated under Articles 14 to 18 of the Constitution. Citing a hypothetical scenario to elucidate his argument, Farasat argued, and I quote here, "For example, I am from Bihar, I live in an apartment. My guard comes and tells me I am an upper caste in Bihar and I have never faced discrimination there. But here I only earn Rs 16,000 and it is difficult to manage it for a family of 4. I take the best case scenario and assume that the 103rd Amendment is for such people. Even then, the exclusion of backward class violates Equality Code. Taking this example only, the guard's annual income translates to Rs 2 lakh. The criteria for EWS reservation is 8 lakhs, so an upper caste earning Rs 2 lakhs is being given benefits. But a more deprived lower caste person is not getting these benefits. In addition to being more deprived, they are also a constitutionally recognized discriminated category. In the three concentric circles, the heart is SCs and STs. What this amendment does is it excludes the heart of it that violates equality. However, the bench interjected at this point and highlighted that those belonging to the backward classes already had protections and reservations granted to them. CJI Lalit remarked, and I quote, "The idea with which this amendment is introduced, I think, is that because there is already a protective umbrella given to backward classes, giving them some kind of protection, that is why they are excluded." Responding to this, Farasat stated by highlighting the difference between the EWS quota and the quota for backward classes. He submitted that the quota for backward classes is a quota for a group and not an individual, and this was done to correct historical wrongs. He also highlighted that the purpose of both the quotas as well as the entities that the quotas were meant for were both different, and thus inclusion in one quota could not mean exclusion from another. Justice Bhat then posed another question, and I quote from the query here, "Keeping aside the argument of exclusion after 75 years, we still see generations of poverty. We see below poverty line, there are a large mass of people falling within that. Why can't there be economic based affirmative action? Even if it is 20%, it's a large mass of people. There will still be a non-discriminated group who are unable to access many things. In theory, government schools are available, jobs are available, but these people are as disadvantaged as others. So per se, what's so wrong if they don't belong to a homogeneous group? Responding to this query, Farasat submitted that there are other methods of affirmative action which could be taken up to address the problems faced by economically disadvantaged groups, which do not require providing them with reservations. He stated that the idea of reservation was to provide reparations to historically disadvantaged groups for the oppressions they had faced. Referring to certain data submitted to the bench, he pertinently stated, and I quote here, "The material shows that at the highest, despite reservations, the backward classes are poorer than the upper caste poor. If there is a correlation, even then the backward class poor is poorer. The backward class is A, more likely to be poor, B, their poverty is deeper and more intense, and C, their poverty is likely to be stickier, more persistent." While elaborating upon his submissions, he explained the concept of multi-dimensional poverty experienced by backward classes. He stated that the backward classes are overrepresented in the poor categories and forward classes are underrepresented in the poor categories. Senior advocate Gopal Sankanarayan, appearing for Youth for Equality, an independent group primarily against caste-based reservations, commenced his arguments by stating that the EWS quota was not an alien concept and had been employed before in cases of right to education, etc. As such, he stated that EWS reservations should not be frowned upon. The gist of his submissions was that the 103rd Amendment violated the 50% ceiling limit, which he argued was a part of the unamendable basic structure of the Constitution, and as such, EWS reservations should be evolved to confine themselves to the 50% ceiling limit. Significantly, he argued that the landmark judgment of the Supreme Court of India in Indira Swani versus Union of India, which had provided for reservations to backward classes on the basis of caste, was no longer relevant because it had been undone by a constitutional amendment. Senior advocate P. Wilson yesterday argued that the scheduled caste and scheduled tribe communities had found a special mention under Article 46 of the Constitution, which stipulates that the state shall promote the educational and economic interests of the weaker sections of the people and in particular of the scheduled castes and the scheduled tribes and protect them from exploitation. He stated that the 103rd Amendment was an infiltration as Article 46 had never envisioned upper caste to fall within its meaning. He further apprised the bench that the explanation to the newly added articles, which state that economically weaker sections shall be such as may be notified by the state from time to time, breached the theory of guided power as provided under the Supreme Court's judgment in M. Nagaraj and others versus Union of India. To this, Justice Bhat remarked, and I quote, "Let us take this argument forward, so then the government only has to set up another commission to determine EWS. That can be remedied. Is that satisfactory?" Senior advocate Wilson answered in negative and continued his submission stating that the 103rd Amendment violated the Equality Code and that the court didn't need to wait for a potential threat to occur. Senior advocate Dr. K.S. Chauhan submitted for the petitioners next and stated that the Indian Constitution has constituted India with certain principles and that Dr. Ambedkar had thought of a society which is moving forward. He argued that the Supreme Court in its judgment, landmark judgment that is, in the Keshavananda Bharati versus State of Kerala had held that the power to amend does not give power to alter the basic structure and accordingly contended that the amendment changes the Constitution's identity. Pertinently, he also submitted that democracy had to be based upon deliberation, but the bill was introduced on 7th Jan, passed in Lok Sabha on 8th Jan and in Rajya Sabha on 9th Jan. However, the bench was unwilling to get into this discussion and Justice Bhat remarked, and I quote, "We are barred from entering into that arena what's spoken in Parliament. We cannot intervene into legislature and this cannot be a ground. We are losing our energy if we talk about that." For more information from yesterday's hearing, you can refer to our detailed report, the link to which has been given in the description box below. Thank you. This is Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.